Assalamu alaikum friends, hope you are fine and enjoying good health. I've started a series of updating superior court's decisions on a monthly basis, which I was describing in Urdu but now I will explain it in English. This is because all professionals can be familiar with the language of the judgments of superior courts, and its only purpose is to share knowledge because it increases by distributing and does not decrease. My first case lies 2022 SCMR page 1806. Sahibullah versus the state. Offences are 302, 324, 212, 34 PPC 1860, Juvenile Justice System Act section 6, 3 and 4. In the present case, the accused was exactly 16 years of age on the date of offence was committed and was not more than 16 years of age. Supreme Court hold when determining juvenility of accused, date of arrest in a criminal case is immaterial. An accused has to be dealt with under the law as applicable on the date that the crime is committed. Accused was admitted to bail. जिस दिन जुर्म सरजद हुआ, मुलजम की उम्र हतमी तौर पर 16 साल थी और उससे ज़्यादा नहीं थी। सुप्रीम कोर्ट ने होल्ड किया कि जुवेनालिटी को डिटरमिन करते वक्त मुलजम की तारीख गिरफ्तारी नहीं देखी जाएगी, बल्कि जिस दिन जुर्म सरजद हुआ उस दिन मुलजम की उम्र देखी जाएगी। चुनांचे मुलजम की ज़मानत सुप्रीम कोर्ट ने मंजूर कर ली। Next case lies 2022 SCMR page 1834, Muhammad Niaz versus the state. Offences are 324, 337 H2, 148, 149 PPC 1860, Constitution of Pakistan 185-3. In this case, counsel for injured witness and the accused both admitted that one of the co-accused had also fired in air. Similar to the accused, was granted pre-arrest bail that was confirmed by the court and was neither challenged by the injured witness nor by the complainant. Case of accused was not distinguishable from the case of the said co-accused. On ground of rule of consistency, accused was granted bail. जख्मी गवाह के वकील और मुलजम दोनों बयानी थे कि एक और शरीके मुलजम जिसने हवा में फायर किए थे उसकी ज़मानत हो चुकी है, जिसे चैलेंज भी नहीं किया गया। मौजूदा मुलजम का रोल भी शरीके मुलजम से मुख्तलिफ नहीं था। चुनांचे सुप्रीम कोर्ट ने रूल ऑफ कंसिस्टेंसी की बिना पर ज़मानत मंजूर कर ली। My next case lies 2022 SCMR page 1882, Sajid Mahmood versus the state. Offence is 302B PPC 1860. In this case, a clear account furnished by the prosecution was reliable, straightforward and confidence inspiring. Both prosecution witnesses was inmates of the house in front of which occurrence took place. Therefore, their presence was natural. Medical evidence available on record corroborated the ocular account so far as the nature, time and impact of the injury on the person of the deceased was concerned. Counsel for the accused could not point out any plausible reason as to why the complainant would falsely involve the accused in the present case and let off the real culprit. FSL report was positive regarding recovered pistol. Mere relationship of a prosecution witness with the deceased cannot be a ground to discard the testimony of such witnesses unless previous enmity or ill will is established on the record to falsely implicate the accused in the case. Supreme Court hold that where ocular account is found trustworthy and confidence inspiring, the same is given preference over medical evidence. Supreme Court explained the question witness mentioned in FIR but whose statement is not recorded under section 161 CRPC. Whether such witness could be examined under section 265F or section 540 CRPC and his evidence could be relied upon. The answer was Supreme Court hold that perusal of section 265F CRPC shows that nowhere in the said section it is mentioned that only those witnesses could be examined whose statement under section 161 CRPC have been recorded. Under section 265 FCRPC, the trial court is not bound to record the statement of only those witnesses who have been listed in the calendar of witnesses. Furthermore, there is no bar that a witness whose statement under section 161 CRPC had not been recorded at the time of investigation cannot be allowed to be examined under section 540 CRPC. When a witness is examined in court whose statement has not been recorded at the time of investigation under section 161 CRPC, the evidentiary value to be attached to the evidence of such witness has to be looked into, and if it is found that prejudice has been caused to the accused, then the evidence of such witness may or may not be acted upon. No universal principle that in every case, interested witnesses should be disbelieved or disinterested witnesses be believed. It all depends upon the rule of prudence and reasonableness to hold that a particular witness was present on scene of crime and that he is making a true statement. Supreme Court explained also rigor mortis. The phrase rigor mortis is Latin, with rigor meaning stiffness and mortis meaning death. Rigor mortis is a temporary condition depending upon body temperature and other conditions. Rigor mortis lasts approximately for 72 hours. The phenomena is caused by the skeletal muscles partially contracting. The muscles are unable to relax, so the joint become fixed in place. My next case lies 2022 SCMR page 1907, Azhar Hussain and another versus the state. Offense is 302B. In this case, medical evidence available on record corroborated the ocular accounts of arrest. The nature, time, the kill, and impact of the injury on the person of the deceased was concerned. No blood-stained earth at place of occurrence. Fire-shot injury causing gut to come of the belly of the deceased. In such like injuries, when the gut comes out of the belly, it seals the margin of the wound and the blood falls inside the body cavity instead of oozing outside the body. Non-existence of blood at the place of occurrence for such injuries is easily understandable and does not shatter the prosecution case. इस केस में मेडिकल शहादत और ज़ुबानी शहादत एक दूसरे से corroborate करती थी। जाए वकुआ से कोई खून आलूद ज़मीन नहीं मिली थी। इसकी वजह यह थी कि पेट से अंतड़ियाँ बाहर आने की वजह से वुंड के किनारे बंद हो जाते हैं, जिसकी वजह से ज़मीन पर खून नहीं गिरता। रिकवरी ना होने और वजह इनाद साबित ना होने की वजह से हाई कोर्ट ने लीनियंट व्यू लिया था और सज़ाए मौत को उम्र कैद में तब्दील कर दिया था। मुलज़म के लिए मज़ीद नरम रवैये की कोई गुंजाइश नहीं थी, चनाचे सुप्रीम कोर्ट ने सज़ा को बरकरार रखा।